Theranos promised to change blood testing with a small drop of blood from a finger. The company said its machines could run many tests faster, cheaper, and with less pain. Investors believed it. Patients trusted it. But behind that promise was a question that could affect health, money, and lives. Were the tests really being run on the company's own machines? The answer became harder to see because Theranos used a wall of secrecy. Its devices were kept from many employees. Its lab work was not easy for outsiders to check. At Walgreens stores in Arizona and California, people paid for blood tests while believing the results came from Theranos technology. Some tests, however, were reportedly run on standard machines made by other companies. That choice mattered because the testing process was the product. Blood had to be taken, moved, prepared, tested, and reported with care. A small mistake at any step could change a result. A person could be told that something was wrong when it was not, or be told that everything was fine when more care was needed. Theranos did not simply face a problem with one machine. The company faced questions about whether its public claims matched its real process. In 2015, reporting by the Wall Street Journal brought those questions into public view. The company denied the reporting and defended its technology, but the story had opened a door that could not easily be closed. For Elizabeth Holmes, the promise had become her identity. She founded Theranos in 2003 after leaving Stanford University. Her black clothing, quiet voice, and strong belief in the mission made her seem unlike a normal business leader. She spoke about helping people find illness earlier and making healthcare easier to reach. That image helped draw in powerful people. Theranos raised hundreds of millions of dollars from investors. Its board included former government leaders and military officials. Its partnerships gave the company weight. But a trusted name can cover a weak foundation for only so long. The deepest cost was not a falling stock price. It was the fear carried by people who had received a medical result. A patient does not see the hidden machine, the lab rule, or the quality check. The patient sees a number and may change medicine, seek more tests, or panic in the middle of the night. That is why laboratory claims are different from ordinary business hype. A delayed package is frustrating. A wrong blood result can shape a person's next decision. Public records and later court evidence showed that the concerns around Theranos were not just about a failed product launch. They involved what investors were told and how patients were served. Holmes stayed at the center as the pressure grew. She appeared on magazine covers, spoke at conferences, and presented Theranos as a safer path into the future. Her public role made the company feel simple. One founder, one bold idea, one mission. But the inside story was more divided. Employees worked in separate groups and were often told little about the full operation. Some people knew the company used commercial testing machines for certain work. Others were told that Theranos technology could perform far more than it actually did, according to evidence later presented in court. The setting was a company built on confidence. Offices in Palo Alto carried the energy of a fast-growing technology startup, yet the work involved clinical testing, where rules are strict and small details matter. Theranos had to meet standards enforced by regulators, not just impress investors or attract headlines. One of the people who questioned the system was Ramesh Balwani. He joined Theranos as an investor and later became its president and chief operating officer. He helped run the business as the company expanded its testing services and sought major partnerships. Balwani was not a laboratory scientist, but he held major power inside the company. That created a serious concern. When a business is built around medical testing, who checks the claims, and who can challenge the people making them? A strong internal review system should slow down risky promises. At Theranos, former employees later described a culture where raising concerns could bring pressure. The paper trail grew when regulators and former workers raised alarms. In 2016, the Centers for Medicare and Medicaid Services reported serious problems after inspecting a Theranos laboratory in California. The agency found deficiencies that threatened the accuracy and reliability of patient testing, and it took action against the company's laboratory operations. For Tyler Shultz, the conflict became personal. He had worked at Theranos and was the grandson of George Shultz, a former Secretary of State who served on the company's board. Tyler Shultz raised concerns about the accuracy of the testing, and later court evidence described efforts inside Theranos to respond to critics and protect the company's claims. Balwani became tied to the same legal storm. Federal prosecutors accused him of helping mislead investors and patients about Theranos' technology and business. Those were allegations until a jury found him guilty in 2022 on all counts in his criminal trial. Holmes had been convicted earlier that year on 4 counts of defrauding investors, while the jury did not convict her on every patient-related count. That distinction is important. Theranos did not collapse because one headline proved every claim false. The collapse came through a chain of testing concerns, employee warnings, regulatory findings, public reporting, and criminal proceedings. The lesson begins with a simple warning. When a company's success depends on trust, check whether its private process can support its public promise. The Theranos case leaves a practical test for anyone evaluating a powerful business claim. Separate the promise from the proof. Ask what technology was actually being used, whether independent experts could examine the results, whether regulators had raised concerns, and whether employees were free to report problems without retaliation. Marketing can describe a future. It cannot establish present accuracy. Investor confidence is not evidence. Secrecy is not validation. And a famous board or respected partner cannot substitute for reliable testing. For patients, the stakes were even higher, because a questionable result could influence a diagnosis, treatment, or decision to seek care. The legal outcomes did not answer every question about every test or every person connected to the company. They did establish that the government's fraud case against Holmes and Balwani reached criminal convictions on specific counts. The warning is precise. When trust is being used to cover a gap between what a company says and what it can independently prove, that gap is where the real risk begins. For Ramesh Balwani, the collapse was not merely a business failure. It became a federal criminal case. In July 2022, a jury in the Northern District of California found him guilty on fraud and conspiracy charges involving Theranos investors and patients. The verdict did not resolve every public claim about the company, but it established that the allegations had entered a serious legal reckoning. The human cost extended far beyond the company's valuation. Employees lost jobs and professional stability. Patients had to question medical results they may have relied on for treatment decisions. Investors lost money. Balwani later received a prison sentence while Elizabeth Holmes faced a separate trial and separate findings. 2 executives stood at the center of one company, but the law judged their conduct independently. Then the laboratory itself became the next witness. Federal inspectors examined Theranos facilities after concerns were raised about the company's testing. Their focus was not whether Holmes appeared persuasive or whether major institutions had endorsed her. It was whether the laboratory could produce accurate, reliable results under federal requirements. The answer had to be found in records, procedures, instruments, quality controls, and documented failures. That changed the story's center of gravity. Theranos could no longer depend on reputation, secrecy, or the confidence of its supporters. Its systems had to withstand outside review by agencies whose job was to protect patients. Once inspectors entered the process, the company's promises had to be compared with operating evidence, not merely repeated by executives or celebrated in public. In 2015, the Centers for Medicare and Medicaid Services, known as CMS, inspected Theranos' laboratory in Newark, California. The agency identified serious deficiencies involving the laboratory's operation and testing practices. CMS later imposed sanctions, including measures that threatened Theranos' ability to conduct testing and affected Holmes' ability to operate a laboratory. The consequences reached the company's core business. A government inspection does not automatically decide every fraud question. It answers a narrower question with enormous practical force. Is the laboratory meeting the rules designed to protect patients? When CMS identified serious failures, Theranos' public claims faced pressure from a different direction. The issue was no longer simply whether investors believed the story, but whether the laboratory could satisfy basic regulatory demands. The paper trail widened again in 2018 when the Securities and Exchange Commission filed a civil complaint. The SEC alleged that Holmes, Balwani, and Theranos misled investors about the company's technology, financial condition, business performance, and relationships with major partners. The complaint placed those allegations into a formal enforcement proceeding and described conduct the agency said violated federal securities laws. A complaint is an allegation, not a final judgment. That distinction matters, especially when claims concern living people and a company that has already collapsed. But an SEC complaint also identifies what the government says it can prove. In this case, the agency described a substantial gap between the image Theranos presented and what its technology and business operations could actually deliver. That gap mattered because investors were not buying an ordinary consumer product. They were buying a vision of medical testing transformed by technology. Many tests from a tiny amount of blood performed quickly, conveniently, and more cheaply. If those claims were false, incomplete, or overstated, the danger extended beyond a failed investment. Patients, doctors, employees, regulators, and the public could all be affected. One employee who saw that gap was Tyler Shultz. He joined Theranos in 2013, while his grandfather, former Secretary of State George Shultz, served on the company's board. Tyler worked with the technology and began questioning whether the company's public testing claims matched the results and limitations he observed inside the laboratory. His concerns came from proximity to the system, not distant speculation. That placed him in a painful position. He was challenging a powerful employer while also questioning a company his grandfather trusted and publicly supported. Theranos operated through strict secrecy, compartmentalized information, and aggressive protection of its claimed technology. In that environment, raising a technical concern could feel like more than an ordinary workplace disagreement. It could look like crossing a line the company expected no one to approach. Tyler left Theranos in 2014. Afterward, he became one of the sources whose concerns helped journalist John Carreyrou investigate the company for the Wall Street Journal. Theranos responded with legal pressure, including threats involving confidentiality agreements and trade secrets. The dispute showed how quickly an internal technical concern could become a personal, legal, and financial threat for the employee who raised it. For a young worker, that danger was not abstract. A former employer could challenge his motives, reputation, and right to discuss what he had witnessed. Confidentiality rules can protect legitimate trade secrets, but they can also create fear when employees are unsure where protected information ends and public safety begins. Even when a worker believes the facts are on their side, legal threats can make silence feel safer. The story then reached George Shultz, a respected elder whose name had helped give Theranos credibility. He had joined the board and believed in Holmes's vision. But Tyler's warnings forced a private family conflict into the center of a much larger corporate crisis. The question was no longer only whether Theranos' technology worked, it was whether trust had overwhelmed the duty to verify. George Shultz initially rejected Tyler's claims. That reaction mattered because trust does not remain inside one person's judgment. It can travel through boardrooms, families, investor networks, and respected institutions. A famous name can make a risky claim appear safer than it is, especially when other decision-makers treat that endorsement as evidence instead of asking for independent confirmation. The family dispute became a test of evidence rather than status. Tyler had to defend what he believed he had seen, while George had to reconsider a company he had helped support and legitimize. Neither side could settle the question through reputation alone. The answer had to come from laboratory records, testing practices, internal communications, regulatory findings, and the company's response to criticism. In the end, one of the clearest warnings was not that Theranos had famous supporters. It was that fame had been permitted to stand in for proof. When a medical company asks for trust, the first question should be direct and testable. Can independent records confirm what the company promises? If the answer depends mainly on secrecy, status, or pressure against dissent, the risk is already visible. Theranos was not built around one machine alone. It was built around a company structure that made the promise seem bigger than the proof. Elizabeth Holmes was chief executive and the public face. Ramesh Balwani helped lead the company's business and daily work. Together, they controlled a system where bold claims moved faster than clear answers. That system mattered because investors and business partners were not simply buying a device. They were buying a story about the future of healthcare. Theranos said its technology could run many blood tests from a tiny sample, but the company kept key details secret and often used conventional machines for patient testing, according to the Securities and Exchange Commission. The next pressure point was the Walgreens deal. In 2013, Theranos began working with Walgreens to offer blood testing through stores, starting in Arizona. The plan gave the company something powerful: a trusted name, a real customer base, and a path into ordinary patients' lives. But the rollout created a hard question. Could the technology perform reliably outside a carefully managed demonstration? Walgreens relied on information from Theranos as it considered the partnership, while the public knew little about how the tests were actually run. That is where corporate procedure became human risk. A company can protect trade secrets, but secrecy does not erase the need for accurate information when people invest money or make health decisions. The legal question was not whether every prediction came true. It was whether important claims were false or misleading when they were made. The stakes rose with every test processed. If a result was wrong, the mistake could reach a doctor, a treatment plan, or a frightened family. A business promise had entered a medical system. In 2018, the SEC accused Theranos, Holmes, and Balwani of a massive fraud. The complaint alleged that investors were misled about the company's technology, business performance, and work with the military. Those were allegations at the time, not a court finding. The case became more serious because the alleged deception was tied to money and trust. Investors were told that Theranos technology had been used by the Department of Defense in the field, while the SEC alleged that the company had not performed the way those statements suggested. The difference between a limited test and a broad success story could change how much a person was willing to invest. For patients, the fear was different. They did not need to understand venture capital or laboratory systems. They only needed to believe that a medical result was dependable. When that trust breaks, people may question not just one report, but every result they received. Some patients sought new testing after reports raised concerns about Theranos results. The available public record does not establish that every patient was harmed in the same way, and the facts varied from person to person, but uncertainty itself became part of the damage. The case then moved from a private company's promises into public scrutiny. Reporting by the Wall Street Journal in 2015 raised questions about the technology and the accuracy of testing at Theranos. The company disputed the reporting, but the claims forced outside institutions to look more closely. The most important shift was simple. Theranos could no longer rely only on its own explanation. Regulators, journalists, investors, patients, and business partners began asking for records that could be checked against the company's public story. Theranos still remained the center of the dispute, but the evidence trail had widened. It now included laboratory inspections, test records, investor materials, communications with partners, and statements about what the machines could do. In 2016, the Centers for Medicare and Medicaid Services cited serious deficiencies at a Theranos laboratory in California. The agency later imposed sanctions, including a ban that prevented Holmes from owning or operating a laboratory for a period of time. Those regulatory actions were separate from the later criminal case, but they added official weight to concerns about the lab's operation. The details mattered because a laboratory is not judged only by how impressive its pitch sounds. It must follow rules for testing, quality control, staff training, and patient safety. A failure in those systems can turn a technical problem into a public health problem. By then, Holmes faced consequences that went far beyond a damaged brand. In 2018, federal prosecutors charged Holmes and Balwani with fraud-related crimes. In 2022, a federal jury convicted Holmes on 4 investor-related counts while acquitting her on other counts. She was sentenced later that year. The outcome reflected the jury's findings on specific charges, not a ruling that every claim made by Theranos was criminal. Holmes's story ended where the opening promise had begun, with trust converted into power. The lesson is not that every new company with secret technology is fraudulent. It is that secrecy, medical claims, famous partners, and confident predictions should never replace records that independent experts can test. When a company asks for your money or your health decisions, the warning sign is not ambition. It is a story that cannot survive careful questions. The practical test is simple. Separate what was promised from what was independently demonstrated. At Theranos, the pressure points were visible in the gap between broad claims and limited verification, in the reliance on secrecy, and in the use of respected names to create confidence that the technology itself had not earned. A medical test is not validated because investors believe in its founder, patients admire its convenience, or a partnership sounds prestigious. It must produce reliable results under controlled procedures, with problems disclosed and corrected. For investors, employees, journalists, and patients, that means asking which claims were tested, by whom, under what conditions, and whether the company's records match its public story. A missing answer is not proof of fraud, and a failed product is not automatically a crime. But when health decisions and millions of dollars depend on the answer, unexplained secrecy and unsupported certainty are not minor imperfections. They are evidence that demands scrutiny before trust becomes irreversible. For Elizabeth Holmes, the collapse was not simply the failure of a company. It was the destruction of a carefully constructed story, a young founder, a revolutionary promise, and a machine that supposedly could transform healthcare. Behind that story were patients who believed a few drops of blood could reveal serious medical conditions, sometimes without knowing how the tests were actually performed. The danger was personal, immediate, and difficult to detect. A wrong result could create panic, trigger unnecessary treatment, delay needed care, or give someone false reassurance. The later federal court record focused on what Holmes and Ramesh Balwani knew, what they told investors and patients, and whether those statements were designed to mislead rather than merely reflect optimism. Holmes remained Theranos' public face as doubts spread inside the company and beyond it. Her interviews, speeches, and investor appearances kept the promise visible, even when questions about the technology were becoming harder to contain. That visibility also meant that the company's credibility was tied closely to one person, making every contradiction more consequential. Her public role gave each warning additional force because the promise did not exist only inside a laboratory. It appeared in interviews, private investor meetings, pharmacy partnerships, and marketing directed at ordinary consumers. People outside the company generally lacked the equipment, technical training, or access to internal records needed to test the claims independently. One of the clearest shifts came through a government inspection of Theranos' laboratory in Newark, California. In 2015, the Centers for Medicare and Medicaid Services, commonly known as CMS, reviewed the facility under federal laboratory regulations. The inspection brought an outside authority into a dispute that had previously been shaped largely by company presentations, assurances, and controlled access. This was not a routine business review and not merely a reaction to unfavorable publicity. CMS oversees clinical laboratories under the Federal Clinical Laboratory Improvement Amendments, often called CLIA. Its concern was whether a laboratory had qualified staff, dependable procedures, appropriate equipment, accurate records, and quality controls strong enough to protect patients receiving medical test results. The inspection report described deficiencies that CMS said could put patient health and safety at risk. That finding changed the stakes. The question was no longer only whether Theranos had exaggerated the capabilities of its technology. Regulators were now examining whether the testing operation itself was reliable and safe enough to produce results that doctors and patients could use. Theranos disputed parts of the criticism and participated in the regulatory process. But a disputed inspection finding can still create severe pressure because a laboratory cannot answer only with branding or confidence. It must demonstrate compliance through procedures, records, qualified personnel, validated methods, and corrective action. The people affected may never see the equipment or understand its limitations. For Ramesh Balwani, the issue reached beyond technical performance. As Theranos' president and chief operating officer, he was involved in operational, financial, and business decisions. Prosecutors later argued that he helped support misleading statements about the company's technology, its testing capabilities, its commercial relationships, and its financial condition. The defense rejected that account. The legal question was specific and demanding. Did the statements cross the line from aggressive promotion into intentional deception? That distinction matters because a failed prediction or ambitious promise is not automatically fraud. Fraud generally requires proof of a material misrepresentation made knowingly with intent to deceive, or in some circumstances through reckless disregard for the truth, depending on the charge and governing law. Investigators examined how Theranos described its proprietary technology, its relationships with companies such as Walgreens, and the number and type of tests performed on its own devices. They also examined what was happening inside the laboratory while those claims were being made publicly. The central issue was whether external assurances matched the methods, results, and limitations known within the company. That was where the paper trail became more important than the polished story. Emails, internal records, investor presentations, laboratory documents, and witness testimony could be compared with the actual testing process. Each comparison created a separate pressure point. Did the company say a test ran on its own device when conventional equipment was involved? Did financial claims reflect documented reality? Balwani's defense challenged the government's interpretation and denied that he intended to defraud investors or patients. In 2022, a federal jury in California found him guilty on charges involving both investors and patients, but that verdict applied to the specific counts and evidence presented at trial. It did not automatically validate every criticism ever made about Theranos or resolve every technical dispute. By then, the company's promise had become a source of intense human strain. Employees faced a choice between protecting their careers and raising concerns about a system that affected real patients. Speaking up could bring isolation, internal conflict, damage to professional relationships, or the loss of a job. In a tightly controlled workplace, even asking questions could carry consequences. That power gap explains why internal warnings can become critical evidence. A junior employee might know that a result was produced on a conventional analyzer, while the public believed it came from a new proprietary device. That same employee might understand that reporting the mismatch could threaten the company, its senior leaders, and the employee's own income and future prospects. The inspection process moved the dispute into a setting governed by evidence rather than presentation. Inside the Newark laboratory, regulators were not judging the confidence of a founder or the appearance of a partnership. They were evaluating procedures, records, equipment, staff qualifications, quality systems, and controls intended to identify errors before results reached patients. A CMS warning could require corrective action and could lead to sanctions or restrictions on a laboratory's operations. In January 2016, CMS announced sanctions against Theranos following its review, including a determination that Holmes could not own or operate a laboratory for a period of time. That action demonstrated that the dispute had consequences beyond investors and public reputation. The public promise had reached the point where a regulator could affect the company's ability to function. That is the warning hidden in the Theranos file. Trust may attract patients, investors, and commercial partners, but trust alone cannot validate a medical claim. Records, independent testing, qualified oversight, and regulatory review determine whether a laboratory deserves to remain open. The earlier complaint mattered because it gave regulators a warning before the public understood how much was at stake. But a warning is not the same as a finding. The harder question was what investigators could prove from laboratory records, internal communications, test results, contracts, and financial statements, rather than from one employee's account alone. That question moved the case from private concern to official review. The Centers for Medicare and Medicaid Services, known as CMS, inspected Theranos' laboratory in Newark, California. The inspection examined whether the facility complied with federal requirements governing clinical laboratories, and it identified serious problems with the way testing was performed and supervised. The inspection did not depend on one unhappy worker or one disputed conversation. It examined the laboratory itself, the testing process, personnel practices, quality controls, and safeguards intended to protect patients. Those details mattered because a medical testing company could not treat accuracy as a marketing preference. The results could influence diagnosis and treatment. That changed the danger for Theranos. A company could dismiss a former worker as confused, bitter, or disloyal. It was much harder to dismiss a federal inspection that raised concerns about patient testing and laboratory operations. Once regulators entered the record, the dispute was no longer only about personalities. It concerned systems, compliance, and potential harm. For Tyler Shultz, the cost was already personal. He had joined Theranos believing he was helping build something important, but raising concerns placed him between his family name, his career, and a powerful company. His decision was not made in an abstract ethics seminar. It affected his employment, his finances, and his willingness to speak publicly. Tyler was also connected to George Shultz, the former Secretary of State who had served on the Theranos board. That family link made the dispute more painful, not less. Tyler was not simply challenging an unfamiliar employer. He was questioning an enterprise that had earned the confidence of someone in his own family and had become part of that family's professional world. Inside the company, Tyler's concerns did not simply vanish when he left. They followed him through legal threats and fear that speaking openly could bring a lawsuit. Theranos used confidentiality agreements and aggressive responses to criticism, and even when the exact legal effect of those threats was disputed, the pressure could still be powerful. His experience showed how secrecy can work in a workplace. A person may not need to be physically trapped to feel trapped. A contract, a threatening letter, the possibility of legal fees, and the risk of losing years of savings can be enough. The practical question becomes not only whether someone is allowed to speak, but whether they can afford the consequences. George Shultz had once trusted Theranos enough to help it gain respect. His presence on the board gave the company the kind of outside credibility that investors and the public noticed. A former Secretary of State carried institutional weight, even though that reputation could not substitute for independent verification of laboratory performance or financial claims. But trust inside a boardroom is not proof that a product works. That distinction became painful when George learned that his grandson had raised concerns about the company. Personal confidence had collided with technical evidence, and the family relationship made it harder to separate loyalty from oversight. The dispute exposed how reputation can delay scrutiny. The conflict reached beyond a family disagreement. It became a question about who had access to the truth, who was willing to hear it, and who might be harmed if warnings were ignored. Patients did not choose laboratory equipment based on boardroom prestige. They relied on results that could shape medical decisions, often without knowing how those results were produced. That is where corporate responsibility enters the story. Directors and executives are expected to take care with a company's claims and decisions, especially when those claims involve health, money, and public safety. That does not mean every director personally performs every test. It does mean serious warning signs can create a duty to ask harder questions and demand reliable answers. The legal system does not treat every failed business as fraud. Fraud requires proof that people made important false statements or hid important facts with the required intent. A product can fail, a forecast can collapse, and a startup can run out of money without automatically meeting that legal standard. The evidence must show more than disappointment. That standard matters because it separates a bold promise that failed from a claim that was knowingly false when it was made. Investigators therefore examined what executives said, what they knew, when they knew it, and whether internal records contradicted the public story. Timing became critical. A statement can carry different legal significance after a warning has been documented. In March 2018, the Securities and Exchange Commission charged Elizabeth Holmes and Ramesh Balwani with a massive fraud involving Theranos investors. The SEC alleged that they misled investors about the company's technology, business results, and relationships with major partners. Those charges were allegations brought by the agency, not a declaration that every allegation had already been proven. The agency also alleged that Theranos performed many patient tests on modified commercial machines rather than the small number of tests Holmes had suggested could be run on the company's own devices. That alleged gap between the public description and the operational reality went directly to the central promise. Whether Theranos had created a revolutionary testing platform or was relying on conventional equipment behind the scenes. Those were allegations in an enforcement action, not automatic proof of every claim. But the filing showed how investigators were building the case, not around one broken machine, but around a larger pattern of statements, laboratory practices, internal records, money, and trust. The legal theory depended on connecting those pieces and showing why the differences mattered to investors. The fraud allegations carried consequences far beyond Theranos' stock value, even though Theranos was not a publicly traded company in the ordinary sense. They threatened careers, damaged family relationships, and raised a question that reaches every workplace and startup. When does confidence become deception? And who checks the story before patients, employees, investors, or families pay the price? The damage from Theranos was not measured only in lost money. It reached patients who trusted laboratory results, employees who feared speaking up, and investors who believed they were financing the future of healthcare. Prosecutors later secured convictions on several fraud charges against Elizabeth Holmes, but the human cost extended beyond any single verdict, settlement, or sentence. A promise intended to make medical testing faster and more accessible had become a reason to stop asking difficult questions. The company's message was emotionally powerful. Less blood, lower cost, quicker answers. But in medicine, confidence cannot substitute for validation. That is where Theranos changed from a bold business story into a warning about trust without proof. The case kept moving through different institutions, investor meetings, Theranos laboratories, Walgreens stores, government offices, and federal court. In each setting, the same basic problem appeared in a different form. Claims made in one room were tested against records created in another, and the gaps between those accounts became increasingly difficult to explain. A company can look strong from the outside while its proof is weak inside. Theranos promoted the idea that a small amount of blood could produce many useful results, yet regulators and later trial evidence showed that the company often used conventional Siemens and other commercial analyzers for tests it had suggested its own technology could perform. That distinction went directly to credibility. The paper trail became harder to ignore. In March 2018, the Securities and Exchange Commission accused Theranos, Holmes, and Ramesh Balwani of raising more than $700 million through false or misleading claims. The agency alleged that investors were misled about the company's technology, its relationship with Walgreens, its military connections, and its financial condition. That filing did not decide every question about every patient, employee, or investor. It did, however, place the company's public story beside detailed allegations from a federal regulator. The claims could then be compared with emails, demonstrations, business records, testimony, and other evidence. The dispute was no longer only about reputation. It had become an official enforcement matter. For Holmes, the pressure became personal and immediate. She was no longer only the young founder praised by investors and featured in major media stories. She was a criminal defendant facing the possibility of prison, financial loss, restitution, and the collapse of the identity she had built around Theranos. The company's success story had become evidence in a federal prosecution. The most painful part was the distance between the image and the evidence. Holmes had become a symbol of courage in an industry where patients and investors often wait years for new treatments and tools. Yet prosecutors argued that she knew important claims were inaccurate or failed to disclose critical limitations when she presented Theranos to investors and business partners. In January 2022, a federal jury in the Northern District of California found Holmes guilty on 4 counts tied to defrauding investors. The jury acquitted her on patient-related charges and did not find her guilty on 3 other investor counts. Those mixed results mattered because they separated proven charges from rejected charges and showed that a broad corporate collapse still has to be analyzed count by count. Holmes's conviction answered one legal question, but it did not erase the people who had trusted the company. Patients still had to wonder whether a past result had been reliable. Employees still had to account for what they had seen. Investors still had to examine how persuasive presentations, selective information, and repeated assurances had influenced decisions before the truth became impossible to contain. Holmes remained at the center of the case, but the company's former power was gone. Theranos shut down in 2018, leaving behind lawsuits, government records, criminal proceedings, and people forced to explain why they had believed in it. The shutdown also meant that the promised technology could no longer be judged by the future results the company had repeatedly invoked. The decline did not happen in one dramatic moment. It came through a chain of actions: whistleblower reports, regulatory inspections, concerns raised by laboratory personnel, a broken Walgreens relationship, investor scrutiny, and government enforcement. Each event added pressure, but the larger significance came from how those events connected and reinforced one another. That chain shows how corporate fraud cases are often built. Investigators compare what a company told investors with what its own records, employees, partners, and regulators were seeing at the same time. A single contradiction may be explained away. A pattern involving technology, revenue, contracts, and internal warnings is much harder to dismiss. For Holmes, the consequences continued after the company disappeared. In November 2022, a federal judge sentenced her to 135 months in prison, followed by supervised release after her conviction on investor fraud charges. The sentence reflected the counts proven at trial and the federal sentencing process, not every allegation ever made about Theranos. That sentence was not a ruling that every story about Theranos had been proven. It was the result of specific criminal counts and the evidence presented for those counts. The patient-related acquittals remained legally significant, just as the investor convictions remained binding consequences. Precision mattered, because public outrage could not replace the elements prosecutors had to prove. Behind the legal language was a person watching a carefully built future fall apart. Holmes had left Stanford, raised enormous sums, gained powerful supporters, and led a company that once carried her name into major conversations about medical technology. The same network that amplified the promise later became part of the record investigators examined. Now the public attention carried a different question. When did ambition become deception? The jury's answer was limited to the charges it considered, but the collapse forced a wider reckoning with how easily a confident founder can be treated as proof of a working product. In healthcare, that mistake can affect money, careers, treatment decisions, and personal safety. Holmes was once presented as the face of Theranos. Later, her own statements, company records, witness testimony, regulatory findings, and government filings became part of the evidence used to judge that face. The practical warning is direct. When a medical company makes extraordinary claims, ask what has been independently validated, what the contracts actually say, and what the internal records reveal. Ramesh Balwani was not a laboratory scientist, but he became a central part of Theranos' business and testing system. That mattered because the company's promise was not just about selling a machine. It was about making patients, investors, doctors, and business partners trust results they could not easily check for themselves. When that trust began to break, the paper trail became more important than the pitch. By 2015, concerns about Theranos reached regulators and people inside the company. The questions were simple but serious. Were the tests being run on the company's own devices, and were patients being told when other machines were used instead? Balwani's role placed him close to those decisions. Later, federal prosecutors argued that he helped mislead investors and patients. His defense disputed those claims, but a federal jury in California found him guilty in 2022 on all counts charged at his trial. The damage did not stay inside the company. It reached pharmacies, doctors, patients, and people who had trusted a familiar medical result with their health. The case also exposed how hard it can be for one person to challenge a powerful company. Employees who raised concerns faced pressure, uncertainty, and the fear that speaking up could destroy a career they had worked years to build. One of those employees was Tyler Shultz, who had worked at Theranos and later became a witness in the government's case. His concerns were not based on a single bad feeling. They came from what he saw in the testing process and from questions about whether the public story matched the laboratory work. The conflict became personal. Shultz was connected to George Shultz, a former United States Secretary of State who had served on Theranos' board. That family connection gave the dispute an added weight, but it did not make the evidence disappear. A company can control access to records, experts, and money. An employee often controls only what they remember, what they save, and whether they are willing to report what they believe is wrong. That is why the inspection records became such a major turning point. In 2015, the Centers for Medicare and Medicaid Services inspected Theranos' laboratory in Newark, California, and found serious problems with the laboratory's operations. The inspection did not by itself prove every allegation made against Theranos, but it created an official record showing that regulators had identified risks tied to the accuracy and reliability of patient testing. That changed the dispute from an internal argument into a public health and compliance problem. Earlier warnings from employees had pointed toward the same basic danger. The company's claims could not be judged only by its marketing. They had to be tested against laboratory records, regulator findings, patient results, and sworn testimony. The later legal cases brought those pieces together. The Securities and Exchange Commission filed a civil fraud action in March 2018, and federal prosecutors brought criminal charges against Holmes and Balwani. The cases involved different legal standards, but both focused on whether investors and patients had been misled. In January 2022, a federal jury found Elizabeth Holmes guilty on 4 counts related to defrauding investors. In July 2022, another federal jury found Balwani guilty on all counts charged at his trial. Those verdicts were findings by juries, not proof that every public claim about the company was true. The deeper lesson is found in the gap between a bold promise and a reliable record. Theranos presented its testing system as faster, easier, and less invasive, while the evidence examined in court raised questions about how much of that promise the company could actually deliver. Tyler Shultz had raised concerns years before the final verdicts. His experience shows why an employee's notes, emails, test records, and reports can matter long after the employee leaves. They may become the only timeline that explains when a warning was made, who received it, and what happened next. For Tyler Shultz, the danger did not end when he left Theranos. After raising concerns, he faced pressure that made speaking up personally expensive, including legal threats and the need to protect private communications. The point is not that every warning automatically proves wrongdoing. The point is that a warning can become evidence when it is specific, documented, and tied to a test, a result, or a defined safety concern. If the response arrives late, the record may show not only what was disputed, but how long the dispute was allowed to continue. That delay matters because trust can outlive verification. Patients may rely on a result before they know how the test was performed. Investors may rely on a claim before they see independent validation. Employees may assume that an internal report will trigger a careful review, only to discover that the real response is containment, intimidation, or silence. The Theranos story ended with criminal convictions for Holmes and Balwani, but the practical warning is broader. When a company makes extraordinary claims, ask what was independently tested, who had access to the underlying data, and what happened immediately after the first credible objection. A late callback is not a harmless administrative detail when people are making medical, financial, or career decisions in the meantime. The deepest damage was not only that Theranos machines failed to deliver what investors were led to expect. Trust itself had become part of the product. Patients trusted the results, doctors trusted the reports, employees trusted the mission, and investors trusted the people making the promises. When that trust broke, each group had to sort through a different kind of loss, while the company's carefully protected story collided with records, testimony, and measurable performance. The record later pointed back to Tyler Shultz, a young employee and grandson of former Secretary of State George Shultz, who questioned Theranos' testing practices while working there. His concerns involved whether the company's technology could produce reliable results and whether internal practices matched public claims. Those objections did not stop Theranos, but they became part of the warning trail examined by regulators, journalists, and jurors after the company's promises began to unravel. By 2015, reporting by the Wall Street Journal had pushed Theranos into a far more dangerous kind of spotlight. The company was no longer being judged only by Elizabeth Holmes' speeches, investor presentations, or partnerships with major retailers. Its test results, laboratory practices, and claims about the Edison technology were being compared with outside evidence. Former employees described a system in which conventional machines were sometimes used when the proprietary devices could not perform the required tests. That shift mattered because a health company cannot rely on a powerful story alone. A blood test produces numbers that may influence a diagnosis, a prescription, or a patient's next medical decision. Accuracy is not a branding preference. It is the foundation of the service. If a result is wrong, the harm may not appear as a dramatic machine failure. It may appear as misplaced reassurance, unnecessary anxiety, or a doctor acting on information that should never have been reported. The legal consequences grew from that gap between claim and proof. In March 2018, the Securities and Exchange Commission accused Theranos, Elizabeth Holmes, and Ramesh Balwani of large-scale fraud involving investors. The SEC alleged that they misled investors about the company's technology, its relationships with the military and commercial partners, and the performance of its blood testing systems. Those were allegations at that stage, not findings of criminal guilt, but they showed that the dispute had moved beyond a failed startup narrative. Holmes settled the SEC case without admitting or denying the allegations. The settlement required her to give up control of Theranos, return shares, pay a $500,000 penalty, and accept a 10-year ban from serving as an officer or director of a public company. The agreement also barred her from participating in the offering, purchase, or sale of securities for a period of time. It was a serious civil resolution, but it did not decide every issue later presented in the criminal trial. That settlement was not a criminal conviction. It was a civil enforcement action brought by a federal financial regulator, and the legal standard and procedure were different from those in a criminal prosecution. The distinction matters because a legal record must be read for what it actually decided, what the parties admitted or disputed, and what questions remained open. One proceeding can impose financial or professional consequences without establishing every element required for criminal punishment. The criminal case reached a different stage. In January 2022, a federal jury in San Jose, California, found Holmes guilty on 4 counts connected to defrauding investors. The jury did not find her guilty on every count. It acquitted her on 4 other counts and did not reach a unanimous verdict on 3, showing that the evidence produced a mixed result rather than a blanket judgment on every allegation. The verdict focused on specific statements and transactions, not on the general success or failure of Theranos. In November 2022, a federal judge sentenced Holmes to more than 11 years in prison after the investor fraud convictions. The case against Balwani ended separately. A jury found him guilty in July 2022 on all counts charged against him, and in December 2022, he received a prison sentence of more than 12 years. Separate trials meant the evidence and legal findings had to be evaluated independently, even though both cases arose from the same company and overlapping conduct. For people who had built their careers around Theranos, the collapse was not an abstract business failure. Jobs disappeared, professional reputations were damaged, and years spent defending a mission suddenly looked different in public. Some employees had believed they were helping make medical testing cheaper and more accessible. Others had raised concerns and then faced pressure, isolation, or legal threats. The company's secrecy had protected its image, but it also made the personal consequences harder for workers to explain once the image collapsed. For patients, the question was more personal and more frightening. If a result came from a test they believed was reliable, they had to wonder whether that result deserved the confidence they had placed in it. The concern was not merely whether a machine looked impressive or whether a store carried the service. It was whether the test had been properly validated, whether quality controls worked, and whether medical professionals had enough accurate information to interpret the result responsibly. The government's case focused on more than exaggerated ambition or optimistic forecasting. Prosecutors argued that Holmes and Balwani misled investors about the technology, the company's business relationships, and the way its tests performed. The allegations included claims that Theranos overstated its military use, suggested support from major pharmaceutical companies, and presented its systems as capable of performing far more tests than the evidence supported. The jury's convictions applied to particular counts and statements, not to every public claim ever made. The defense disputed those claims and challenged how responsibility should be understood. That competing account is important because a company can fail without every failure being fraud. Startups miss projections, technologies break down, and executives can be sincerely wrong. The legal question was narrower and more demanding, whether particular statements were knowingly false or misleading when they were made, and whether those statements were used to obtain money from investors. That is where the paper trail became powerful. Public statements, investor presentations, financial records, internal concerns, emails, laboratory evidence, and witness testimony allowed jurors to compare what outsiders were told with what people inside the company understood. The issue was not simply whether Theranos had a bold vision. It was whether the company's private knowledge had diverged so sharply from its public claims that the promises became deliberate deception rather than ordinary business optimism. Theranos dissolved in September 2018. Its name vanished from the marketplace, but the larger result remained. Investors became more alert to private companies that guarded technical claims behind secrecy, celebrity support, prestigious board members, and promises of a better future. Regulators and lawmakers also faced renewed questions about oversight, private company disclosures, laboratory regulation, and the difficulty of testing a business whose most important evidence is kept from independent review. The story also changed how many people viewed expert status. A famous board member, a respected partner, or a high-profile investor could make a company look safe, but none of those signals replaced independent testing and careful records. Authority can open doors and reduce skepticism, yet it cannot validate a laboratory method. The same warning applies beyond healthcare. Reputation may explain why people listen, but evidence is what determines whether a technical or financial claim deserves belief. One question may never be answered completely. How many people accepted Theranos claims because they trusted the science, and how many accepted them because they trusted the people presenting it? The record can show statements, actions, warnings, investments, test results, and legal outcomes. It cannot measure every private decision made by a patient, doctor, employee, or investor. Some relied on apparent expertise, some relied on social proof, and some may have relied on hope when independent evidence was difficult to obtain. The lasting lesson is concrete. When a company asks for money, loyalty, or medical trust, look for evidence that can be checked outside the company's own story. Ask who independently tested the technology, whether the records match the presentation, and what happens when insiders raise concerns. Claims should meet records, records should meet results, and confidence should never be treated as proof. In a dispute like Theranos, the warning sign is the distance between what a company says and what outsiders are allowed to verify. The wider damage was not just the money lost by investors. Theranos changed how people looked at bold health claims. A famous name, a private laboratory, and a promise to change medicine could no longer stand in for proof. The central warning was simple. Reputation may attract attention, but it cannot validate a medical result or replace independent testing. That shift reached far beyond one company. In the public record, the Securities and Exchange Commission case filed in 2018, along with the criminal trials that followed, showed why claims about medical tests carry a special risk. When a result may guide a real person's care, trust must be checked against performance data, laboratory records, regulatory requirements, and independent review. But one question still remains difficult to answer. How many patients changed what they did because of Theranos test results, and how many were never told that those results may have been inaccurate? A patient might repeat a test, seek treatment, postpone treatment, or carry a new fear into a doctor's office. The missing answers matter because the decisions cannot always be reconstructed later. The available record cannot fully measure that harm. Some people may have taken needless fear into a doctor's office after receiving an alarming result. Others may have received false comfort from a result that failed to reveal a problem. Even when a later test corrected the record, the first result may already have changed a conversation, a prescription, or a family's understanding of what came next. The lasting result was a stronger warning around private health companies that promise a fast breakthrough. Investors, doctors, regulators, and patients all had more reason to ask how a test works, which instruments actually perform it, who validated the process, and whether the company is showing the full record. A polished demonstration could no longer answer questions that belong to laboratory science. That is the durable lesson from Theranos. A company can raise money with a story, recruit employees with a mission, and attract powerful supporters through confidence. But a medical test must earn trust one verified result at a time. The claim has to survive quality controls, comparison with established methods, and scrutiny from people who are free to challenge it. For workers inside the company, the aftermath was also personal. Careers were tied to a name that once seemed powerful, and people who had joined to build something important had to live with the collapse of that belief. Former employees faced damaged professional relationships, difficult questions about what they knew, and the uncomfortable divide between protecting confidential information and reporting serious concerns. For patients and families, the cost was even closer to home. A laboratory result is not just a number on a page. It can shape fear, hope, treatment, insurance conversations, and the next choice a person makes. When confidence in the result breaks, the patient may be left wondering not only whether one answer was wrong, but which other decisions were built on it. The aftershock also changed the meaning of secrecy. Keeping a new invention private can protect a trade secret, preserve a competitive advantage, or limit access to unfinished research, but secrecy cannot replace safety checks when the product affects the public. A company may withhold proprietary details from competitors while still providing regulators, doctors, and patients with the information needed to evaluate safety and reliability. That line matters in every growing company. Confidential plans may be normal, especially during research and development. Hiding basic proof from the people who must rely on a claim is something else. The difference often appears in ordinary questions: what was tested, under what conditions, against which standard, with what error rate, and who had authority to review the answer. The record still cannot tell us whether every person involved understood the full reach of the problems at the same time. Some facts became public, some were disputed, and some were known only inside the company. That matters when judging responsibility. A public accusation is not the same as a court finding, and a later conviction does not automatically answer every question about every employee or patient. That uncertainty is why careful language matters. The convictions of Elizabeth Holmes and Ramesh Balwani resolved criminal questions about investor fraud under the verdicts returned in their separate federal trials. They did not turn every unanswered question about every patient into a simple story. The legal findings established specific criminal liability, while the broader human consequences remained harder to measure. The long-term consequence is a new habit of checking trust before commitment. Before investing, taking a job, signing a deal, or relying on a health claim, look for independent proof, clear records, and a way to challenge the promise. Ask whether the evidence comes from the company alone, whether qualified outsiders examined it, and whether inconvenient results were preserved rather than quietly discarded. In the end, the warning is small enough to miss. A trusted name is still only a name until the evidence can stand on its own. When the claim involves a person's health, money, or future, confidence is not verification. The safer question is not who believes the promise, but what records, tests, and independent findings remain after the promise is put under pressure. If you want to stay protected and get legal help, click the link in the description to visit wagehelpcenter.com.